Welcome to Public Forum, a community outreach program produced at North Idaho College on the shores of Lake Coeur d'Alene. Featuring guests from around the globe addressing a wide variety of subjects, Public Forum serves to educate and enlighten. Please join host and moderator, political scientist Tony Stewart, in welcoming today's guest.
Good afternoon and evening, depending on where you are in this broadcast. We have a very important subject today, and that has to do with the issue of the right to die and when life support systems can be removed. We're most fortunate to have a true legal expert, and one of the best in the country. We welcome to the program Bill Colby, is the attorney who represented the family of Nancy Cruzan in the first right to die case heard by the United States Supreme Court. And that case was from the state of Missouri. And at present, he is a senior fellow of the National Hospice and Palliative Care. And he's traveled to Idaho to speak at a conference and was so gracious to come by and be with us. He, as I said, travels across the country speaking about the complicated issues society faces in the end-of-life issues. He has appeared on CNN, Larry King Live, Good Morning America, MSNBC, Today, Hardball, CBS This Morning, and a number of other programs, and is the author of two books. And one of those books, the most recent one that came out this year in 2006, called Unplugged, Reclaiming Our Right to Die in America. And I have a copy here, and we would recommend this book certainly to you. And in 2002, he wrote a book called Long Goodbye, The Death of Nancy Cruzan. It's a real pleasure, Mr. Colby, to have you on our program, and we really look forward to this interview.
I appreciate you having me. Good to be with you.
And as always, I'm pleased to have a regular panelist, Erna Reinhardt, who's Director of Public Relations at North Idaho College, and Erna will commence the questioning with our distinguished guest.
Bill, welcome to the show. It's an honor to have you here.
Oh.
We're delighted.
Pleased to be here. Thanks.
We're going to be talking today about some very sensitive issues, and before we get too far into the program, I wanted you to give our viewers an overview of the case that you were so intricately involved in. It was the Nancy Cruzan case. And maybe start out by telling us how you got involved in that case, what were some of the medical facts with that case, and what were some of the legal facts regarding that case.
Okay, sure. Began in the mid-'80s. As a fairly young lawyer, I did a lot of public service work and took on this case for a Missouri family whose story, like a lot of families, tragic stories, the bad car wreck, the phone call in the night from the state trooper that changes life forever for those people. And ultimately, the Cruzan family found that Nancy was in a medical condition similar to the condition that many people watched on the television in the last year with Terri Schiavo, a kind of a counterintuitive diagnosis that's the product of modern medical technology, a kind of unconsciousness where some part of your brain stem still exists, called the persistent vegetative state, but where all consciousness, all thought, all feeling, those parts of the brain, because of lack of oxygen, are gone. And the family came to the point where they realized this condition, and they were faced with two choices, both of them bad. They could leave her in that condition. Doctors said she could live another 40 years without hope of recovering consciousness, or they could seek removal of that, the only technology in place keeping her alive, which was a simple feeding tube that they had consented to shortly after the accident. As they started to talk about those choices as a family, they realized that if Nancy could speak, she'd say, given those bad choices, I want the tube out. That's what they decided they wanted for her as well. This was a new question, both nationally certainly, but in Missouri in 1987, found their way into the court system, and ultimately Cruzan went to the United States Supreme Court, and it's the only one of those cases the United States Supreme Court has addressed, and that case established the constitutional right that the three of us have to make decisions about our own medical treatment. So that's the rough thumbnail sketch of the case.
And did her medical condition change throughout any of these legal battles?
No. When the vegetative state, the stem of our brain where our basic reflexes are housed can go much longer without oxygen and survive, as opposed to the upper thinking part of our brain. The vegetative state was first defined in the medical literature in 1972 as doctors started to see, because of improved accident site resuscitation technique, improved emergency rooms, improved respirators, technology starting to grow, doctors started started to see more of these patients whose eyes were open, but who were unaware. A counterintuitive, as I said, diagnosis, but one that technology has brought us. Nancy was without oxygen at the accident site almost 30 minutes. So there was, in hindsight, we knew there was no chance she would ever recover consciousness, but she was very much alive. She was not brain dead. That simply led to the next question, and a very hard question, and one we're talking about all the time today. What's the purpose of medical technology? When do we stop using it if it's not serving that purpose? And who decides? And that's the discussion that played out in the case. But her diagnosis did not change.
And Bill, tell us a little bit about her family members. Did she have a husband, kids, parents, and who was involved in those decisions? And were they all unified in their decision?
She was 25 at the time of her accident. She was married. Her parents and her sister and her husband initially were all very much involved. Her husband, as time went on, grew more detached and realized his wife was not coming back, and he essentially went on with his life. And so it was her initial nuclear family involved, and they were united in the belief that if she could speak, she'd say, "This would be my, among those bad choices, this would be my choice."
Great.
In addition to this case, there was the case in New Jersey some years ago, and then the case in Florida last year. And of course, there are others that we don't hear about. But in all those cases, with the modern technology we have, we know that when the brain reaches a certain condition and the absence of oxygen, we don't have any examples where there's been a recovery after a certain deterioration. Is that correct?
Well, I think and again, as a lawyer, I've been involved in a lot of these cases. I'm not a doctor, but I think with all of medical science, there's a certain need to approach what we know with a certain amount of humility. The diagnosis of a persistent vegetative state of permanent unconsciousness and no consciousness whatsoever, no ability to perceive, no perception of pain. That was the American Academy of Neurology first set out the guidelines for making that diagnosis in 1986. It's predominantly a clinical or a bedside diagnosis made by careful observation over time, confirmed by various laboratory and technical studies like CAT scans that show lack of brain tissue where we know brain tissue exists, but it's primarily made through observation. Anecdotally, over the years, there are stories we hear of now and then of someone waking up from a coma or someone showing perception where once it was not there. So to me, that suggests we need to be very careful about our medical assessment and very careful about how we treat and evaluate brain-injured patients. That said, someone who's been without oxygen for an extended period of time, like Nancy Cruzan or like Terri Schiavo, there are not reported cases of a patient recovering consciousness after that kind of lack of anoxic or lack of oxygen type of injury. The lack of oxygen destroys the brain cells permanently, and they can't regenerate. It's not like a head injury.
Yes. In those cases where someone regains consciousness, if I understand what you're saying correctly, they don't have that same level of destruction of the brain of those that regain consciousness.
Well, and there are all kinds of levels of brain injury also, and all kinds of new sorts of treatment and new ways of assessing injury. And to me, that really gets to the heart of what the questions are that cases like this bring up, which is, again, what's this technology for? When do we use it? When do we stop? And when it can return us so that we can sit here and talk about these questions, or that we can interact with people we care about, then I think the technology serves one purpose. When it cannot, then I think we have hard decisions about when we use and when we don't use that technology. And they're new questions. I mean, we're really just starting to discuss these questions in our culture.
I apologize. I have a terrible cold today, and so it's hard to.
Is there pollen? Is there pollen in Idaho too?
Yes, yes. And my
Lord knows we've sent a lot of it out from Kansas. So
yeah, it really
apologies for that.
But in relation to these conditions medically, oftentimes some of the patients have systems, medical systems that they're attached to. We call it life support systems, but and maybe there's a breathing mechanism and all that. And in others where it's my understanding that they're not hooked to those particular machines, but there's the feeding tube. And so does that make a difference depending on, in other words, is it true that if you disconnect technical medical machinery in some cases, even if you were going to use a feeding tube, they would die because of the respiratory problems?
Yeah, it's an interesting question. Feeding in all cultures, and in our culture certainly, has a certain special place. I've got 4 children. I nurture them. I care for them. I feed them, and feeding is part of our rituals. And I think that's part of why when we hear the word feeding tube, we have an instant reaction perhaps that that's somehow different than a respirator or a dialysis machine. The Supreme Court in Cruzan and most medical societies come to the conclusion that artificial nutrition and hydration, tube feeding, is technology like a respirator, like dialysis. It's a device that's taken the place of a natural function that's been lost, typically intended to serve as a bridge to recovery of that function. So I think most groups look at it as a technology, but again, recognizing that feeding has a special place, and so some of our laws treat feeding tubes differently. When you fill out a living will in some states, you're required to say the person I've given the decision-making power to can make all decisions, including tube feeding. So it's treated specially. When we started the Cruzan case in 1987, we had a debate over 3 years, initially just within Missouri and eventually throughout the country, about exactly that question. And people were starting to try to get their hands around it. Even something you think of as being as simple as tube feeding. When we were at the Supreme Court, one of the groups that filed a brief supporting the family, it's the Trade Association of Doctors and Nurses who are actively involved in tube feeding. Their brief to the court said that tube feeding had only grown sophisticated enough in the last 10 years or so, since about 1980, that you could keep someone in an extended unconscious state like Nancy Cruzan with tube feeding. So even something that you think of as that's as simple as tube feeding, the technology has changed, evolved, and it's brought with it hard questions.
And one final before going back to the panel. In your client's case, in the end, the feeding tube was removed, and then she passed away. Is that correct?
Yeah, she died 11 days after her tube was removed. After the U.S. Supreme Court, we went back for a second trial at the lowest level, at the trial court level. Again, the trial court ruled in the family's favor. This time, our Attorney General made the decision not to appeal that ruling. Her tube was removed. And over the course of the next 11 days, it was a very peaceful, reverent, sacred time among family gathered around a loved one who was dying. She showed no distress whatsoever in any way, and her body, without a brain, essentially simply shut down. And there, but for the grace of God, go the rest of us. I mean, that family was faced with only bad choices, and they did what they thought was right.
Right. That's there to have great empathy in those difficult times. Now, from the time that her accident until her death, what time period are we talking there?
About 8 years, just under 8 years.
Mm-hmm. Thank you. Erna Reinhardt.
Bill, share with us and share with our viewers, are there some things that families and individuals can do to make sure that their wishes on how they want those last few hours or days to be will be honored? Is there some advice that you would have for individuals and for families?
It's a good question, and just to put it in a little context before I answer that, I hear people in the world of bioethics, a brand new discipline all by itself, didn't exist 25 years ago. Basically, it's grown out of this technology. But I hear them say, you talked about the Quinlan case in New Jersey in 1975, that we've been working on these right to die questions since Quinlan in 75, and we still haven't figured them out. And there's a certain sense of frustration when they say that. My take is really just the opposite. I think we've only been working on these questions for 30 years or so. They are incredibly difficult. They have come at us in this just amazing rush of medical technology, and just as we start to figure a question out, the technology evolves. But I'm a baby boomer. My parents are their generation are the very first human beings who have ever asked what we're talking about today, what is an incredibly profound question. Is there something this doctor has to offer me, either medicine or machinery, that I would not want? Never before asked, because we wanted everything. It wasn't long ago that the doctors just did not have this massive array of tools. Now they do. So much of our dying happens in institutions as a result of some decision about medicine or machinery. So we need to have this talk, but I think sometimes people they're a little hard on themselves. I wouldn't try to set up the standard to try to be perfect, because it's hard to understand that whole world and how to navigate your way, and there are many ways to navigate. But I think people can do three things, take 3 steps, which will prepare their family as well as I think probably any other way. First, there are legal pieces of paper. I think the best piece of paper to fill out is the simplest one. It's called a power of attorney for health care, where a lot of people have heard about living wills, where you try to anticipate conditions and treatments, and I think those have some use. I think the better piece of paper is the one where you simply say, if I can't speak about my medical condition, here's who speaks for me. So it's not necessarily anticipating conditions, but just naming the person.
And does it have to be one individual?
Well, it's better to have it be one and then alternates. Some people try to list their group of 3 adult children as the group deciders. I think that's not a good way. I think find the one person, but then second, you need to talk with that person about your views and values and about these stories about Nancy Cruzan and Terri Schiavo and the story of the neighbor across the street. And then third, and a critical point in going to your question, is that you have to reach out to everyone who might be in the room when that discussion happens, when those decisions are made, including the other 2 adult siblings who weren't named the decision maker, and the brother who you didn't get along with that well before he moved away 8 years ago. Reach out to everybody, let them know about these discussions so that they can be supportive of the decision maker when the time comes. And if you take those 3 steps, the power of attorney, talking to the person to arm them as your advocate, and then talking with others who will be in the room, I think that's about as good a way as any to prepare people you care about for hard decisions ahead. And then we had that discussion one year in my family over Thanksgiving, and then we finished it up and we went and played Scrabble. And I really think that's a gift to people you care about.
Great advice, thank you.
And on that same subject, I think that was one of the real issues in the Florida case with the Terri Schiavo case. She did not have any of those documents. Her husband had indicated that they'd had those conversations. Her parents said they'd not had those conversations. So the advice you've given, if that had been in place, it wouldn't necessarily solve the issue completely, but it would have certainly been, wouldn't that have been a help to the courts in particular when they had to enter the issue?
Yeah, it's a good question. I think had all that happened, the courts probably would have never become involved. A different version of that question that I've gotten from time to time from journalists is, well, if Terri Schiavo had had a living will, then we wouldn't have any of these issues, right? And I think that's probably not right. I think had she had a living will, it likely wouldn't have made much difference at all. I think there still would have been that family dispute, because it wasn't really about the law. The law in Florida that applied in the Schiavo case was pretty clear cut, that the husband was the decision maker and that he was making a medically appropriate decision. It just ended up not mattering because not only did that family not have that discussion, they'd had a very serious family fight. They hadn't talked for many years, so they had this festering relationship. And when I did commentary at various places on the Schiavo case, I tried to emphasize exactly that point, which is, let's not try and pick sides here because none of us know enough from news coverage to know all the facts and factors that went into that family dynamic. But think about the 6 years prior to her cardiac arrest, the first 6 years of Terri and Michael Schiavo's marriage, when for a period of time. They lived with Bob and Mary Schindler, when they traveled together, when they broke bread together. What if just once she had taken the step of talking with those three people she loved about Nancy Cruzan for 2 minutes? Would she have spared them all that they went through? We don't know. We do know that in the wake of that case, literally millions of people have had a discussion around Terri Schiavo at the National Hospice Group where I'm affiliated. One website for one nonprofit where you can go to download free state documents, living wills, powers of attorney. It's caringinfo.org. It's a great website, caringinfo.org. They had in 18 months over 2 million hits of people looking for documents, and that's one group. So there is a good that comes out of these horrible family tragedies, but just having the piece of paper, your question's a good one. I don't think it would have made a whit of difference.
That's important to know that what you recommended with the power of attorney for health care and also the conversation with the family is much better than just going to an attorney yourself and having a living will. One other issue is that in some cases where families have all this done, maybe as proper as they can, and when those times come and they're just consulting with their physician, and it's quite private, the public doesn't get involved. And so don't we have a lot of cases where when it doesn't go public, then you don't have the demonstrations outside of the hospital and many groups coming on both sides? That's likely not to happen if you don't have to make this so public.
Oh, no question. I mean, today in the United States, roughly 7,000 people died. Tomorrow the same, the next day the same. I mean, it's part of our population and our lifestyle. There's not a big rush to the courthouses. That's not happening in the courts. The much bigger problem than a Cruzan or Schiavo lawsuit is the situation where families are troubled by guilt and by doubt and by lack of information and by indecision, so that they muddle through, and we get through it because that's the natural order of things. We have to get through it. So the solution to that, and why would you not give your family the information they need? I mean, that time, I've been through it now with different family members. That time is hard enough when you know exactly the views and values of the person, and you're all on the same page, and you know what's ethically and morally and legally right. It's still profoundly difficult to make decisions about medical treatment. But when you haven't had that discussion and don't know any of that information, it's exponentially worse.
One of the things, I'm one of the founders of Hospice North Idaho years ago, and you're with Hospice. I think it's just a remarkable organization, and they do great work of teaching people how to deal with dying and also not having the guilt. I would like to get you to react with all your experiences. A lot of medical centers in America have created both a committee and they have an ethicist on board. And is that not a lot of help in these situations where, the wonderful people have oftentimes such a guilt that they really don't need to have? Is that helping in these situations by having those experts and those committees at those medical centers?
I think ethics committees can help, and particularly at medical centers, they're brought in when there's a dispute. But again, I think what's even more useful in the medical setting are people who are good at talking with families about hard issues. And sometimes it's a doctor in one place, another place it'll be a nurse or a chaplain. But there's no magic to how you do that. It's just people who are caring and thoughtful and willing to spend the time and good at walking families through profoundly hard questions. A lot of the National Hospice Organization, as you know, is now called the National Hospice and Palliative Care Organization, and there's a specialty that's been growing of doctors focused on palliative care in the institutional setting, where they're talking with families about the goals of treatment and the fact that this treatment's not going to cure their loved ones, so they need to be thinking about all of the issues related to that. That specialty was recently approved for board certification. More and more hospitals are having palliative care consults where you can call, not necessarily the ethics committee, although often the membership overlaps, but you call the head of the palliative service, and someone comes down and sits down and talks with a family who's good at understanding these questions about what's the goal of medical care. In the state survey that was just released today for by the End of Life Coalition and the Center for Aging at Boise State of Idaho citizens, very interesting survey. We were just down with the looking at the results of that. 80% of people in Idaho, when surveyed, said that when the time comes, they hope to be at home, surrounded by loved one, free from pain, and hopefully not tethered to machines. And the reality, of course, is almost directly the opposite. In addition, 80% of people in Idaho said they wished that someone in their family would initiate this conversation. Well, what an amazing opportunity where we're getting care we don't want, and we all want to talk about it. We have a holiday coming up. Say, I can't believe I was listening. I didn't change the channel. This lawyer was talking about this stuff. Here's the story he talked about. Here's what I think about Terri Schiavo, Mom. Yeah. What do you think? What a great opportunity your show could give to people.
The bottom line is communications before the crisis. And so certainly you have indicated that. We're just really short on time, but with about a minute left, what other advice would you give families other than what we've talked about? And I should add that you're a graduate of the law school at the University of Kansas, and you have this wonderful background. From that experience, what else have we not talked about that would be helpful?
Well, I suppose people take some, and doctors I know especially do. You know, doctors and lawyers, we somehow exist together and we get along, but take some comfort in hearing from a lawyer that this really isn't about the law. I mean, the cases grew up in the law, and the law is involved through the provision of these written documents, often by state statutes. But the black and white of the law can only go so far in the gray, human, emotional time that's serious illness and dying. And if you want to really give a gift to people you care about, it's have this talk upstream from illness when everyone's relatively healthy. It's a gift.
On that note, we have to bring a permanent conclusion. I just got to tell you, after doing this for 35 years, this is one of my favorite programs. William Colby, an attorney who has been talking about the right to life and the right to death. Thank you. It's been very, very informative.
Thanks for having me.
And ladies and gentlemen, I hope you'll be with us again next week at the same time. We'll discuss yet another issue. Until then, please have a good week. I am Tony Stewart.
Recorded on the campus of North Idaho College, Public Forum is the longest-running in-house college production on PBS. Each episode is pre-recorded live and is an educational outreach from North Idaho College. Please join us at this same time next week for another edition of Public Forum on this public television station.